Non-edit. No. Yeah. Looking na side to slop ho jabo. Online eku guru na paribo. Huh? Lao, Johnny.
May I please, my lord. Lordship, I beg to mention item number 3, Lordship.
Item 3.
Yes, Lordship. On behalf of Imti Longjam, Lordship. Lordship, he is not well and going medical treatment, no, Lordship. So if this matter may be listed after 4 weeks, my lord, for respond number 1.
Oh. This matter was earlier part heard, and thereafter this IA was filed. Okay. When do you want to say?
After 4 weeks, your Lordship.
After 4 weeks?
Yes, your Lordship.
Yeah, I have no objection, my lord.
No objection.
My lord.
The IA was filed by you?
Yes, my lord.
Oh, I thought of considering IA.
No, my lord.
Today. So, you are for respondent?
Respond number 1, your Lordship.
Okay. Miss, your name is not there?
Yes, sir, I'm not there. I'm just submitting on behalf of Mr. Longjam.
Why you are seeking adjournment?
Lordship, he is not well and going medical treatment.
Who?
Mr. Imti Longjam.
Okay. Yes, some ministers, the conducting counsel for the respondent number, Miss Imti Longjang. She is for respondent number?
1, Lordship.
Respondent number 1 is not well, therefore pray for adjournment of the matter for 4 weeks. To which Mr. N.K. Lui Kamlani counsel for the petitioner has no objection. The applicant,
Yes,
petitioner
applicant.
has no appellant has no objection. Accordingly, the prayer is allowed. List this matter after 4 weeks.
Who's up, please?
Lordship, I have a similar prayer for item number 15 also. On behalf of Mr. Imti Longjam, Lordship. Here, he's for the appellant, Lordship.
Okay. Have you informed the other side?
Yes, your Lordship.
Okay, Miss Mr. Some ministers. Same thing, no? Imti Longjam, Lani counsel for the petitioner is not well, therefore pray for adjournment of the matter. She has also obtained consent from the counsel of the other side. The prayer is allowed. List this matter after
4 weeks,
4
Lordship.
weeks. Okay.
Much already.
Yeah, please, Your Lordship. I beg to mention items number 4 to 7. Lordship, if this matter may be adjourned since my senior is indisposed. Item 4 to 7.
4 to 7?
Yes, Lordship.
4 is a part?
Yes,
part?
Lordship.
Okay.
My senior is
7
indisposed.
4 to 7?
Yes, Lordship. 4 to 7.
Lordship, I'm appearing for respondent number 6, Lordship,
Yes.
in item number 4, Lordship. And respondent number 2 in item number 6, Lordship.
I think we have heard the petition.
Yes, almost the hearing is
And it was, your part was,
yes,
I think.
yes,
petitioner would have heard.
yes.
Can you see it?
Lordship. If my lord, yes, if my lord is willing to take up the matter, then I'm ready.
Because this
with
is
it,
part heard only, otherwise I'll have to release it. We'll see it, okay. If it is possible,
Okay.
Okay, Lordship.
okay, wait for some time. Huh?
Lordship.
Item 4. Yes, 4 to 7.
Item 4 to 7.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 14, Your Lordship. Mr. Lordship, this morning only I have received a copy filed by the respondent number 1, Your Lordship, affidavit in opposition, so I might be allowed some time to go through the affidavit, Your Lordship.
Okay. You are Mr.
Jingjangpong for Gauhati.
Chinjampo, Land Council appearing on behalf of Mr. Yangarvati, Land Council for the appellant, submits that he had just received the affidavit in opposition filed by the respondent and needs some time to go through the same. Mr.
Pangom Deplukaman.
Land Council appear on behalf of the respondent.
Yes, sir.
Okay. As per for come list this matter after
3 weeks, Your
3
Lordship.
weeks. Okay.
Obliged, Your Lordship.
Obliged, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 13 on behalf of Mr. Tushiolongkumar. The counsel for the petitioner he has some personal difficulties, so I pray that the matter may be listed after 3 weeks.
No.
No objection, Lordship.
Miss
Esther Chakre, Lordship.
Land Council submits that the Land Council for the petitioner, the Land Conducting Council for the petitioner, Mr. Tosi Olongkumar, has some personal difficulties today and therefore pray for adjournment of the matter for the day, to which Miss Chang, Land Government Advocate, has no objection. Putting the prayer is allowed. List this matter after
3 weeks, Your
3
Lordship.
weeks. Okay.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention hearing item number 12. Kindly let this matter come after 3 weeks
Okay. You are for the
for the petitioner.
Petitioner.
Yes, Your Lordship.
okay. No objection.
No objection, Your Lordship.
On the prayer of the Land Council appearing on behalf of the petitioner and not being objected to by the Land Council for the respondent, this matter, let this matter be listed after
3 weeks, Your
3
Lordship.
weeks. Okay.
Obliged, Your Lordship.
3 weeks. Okay.
May I please, Your Lordship? Lordship, may I be pleased to mention item number 8, 9, and 10, hearing item number 8, 9, and 10. Your Lordship, if this matter can come up after vacation, Your Lordship, because Your Lordship, some matter is pending before the Apex Court, Your Lordship.
Okay. Miss.
Yes, Your Lordship. It's a consensus prayer. The petitioners are absent.
Okay. With the consent of the Land Council for the petitioner, prays for listing this matter after
Vacation, Your Lordship.
the entry winter vacation. The prayer is allowed. List this matter after the vacation. Okay.
Much obliged.
May I please, Lordship? Lordship, I beg to mention hearing at number 11. Here, petitioner is absent, but only yesterday I received 2 IS. So this matter may not be listed in the hearing list.
Okay.
I'm for the respondent.
In this petition, 2 IS filed.
Yeah, I received two IS yesterday for implementing the respondent.
Okay.
But the petitioner is absent today.
Petitioner is not present.
Oh.
Oh, you are for the petitioner.
Yes, Lordship.
You have filed IA for what?
We have filed IA to allow implement and then IA for amendment of the main petition.
Okay.
Two IA. Pangom W. Kaman for Mr. Pakin Richapu, my senior counsel.
Nagaland Council appearing on behalf of Mr. Pakin Richapu, Nagaland Council for the petition submitter. He has filed 2 IA, 1 for implement of the
Party,
Party implement of the party.
new party
Yes.
New party.
Yes, Lordship.
of the party and for one is for
amendment of the
main
amendment of entire.
partly, Lordship.
Maybe
Amendment
a
of the main
cost
petition.
title, maybe a cost title, since they are amending the, implementing the new party.
Okay, in view of the above, let this matter be listed along with the IAs for order
Yes, it has.
Yes, Lordship.
after 3 weeks. Okay.
Obliged, Lordship.
For hearing, I beg your pardon, for admission, item numbers 1 and 2.
Yes.
Please, Your Lordship.
1 and 2, the petitioner are the same person.
There are
Different.
two petitioners, Lordship.
Two
There are
petitioner.
Two petitioners, Lordship.
Lane different.
Initially, the petitioner number 1, he bought a plot of land for which
Lane from
land from a private party, Lordship.
private.
So-
Who is private party?
From one named Kiviki Lesurye.
Okay. And then who is this petitioner number 2?
Petitioner number 2 is the
No, not petitioner number 2. The petitioner.
The petitioner.
In, item 2. He also purchased.
He is the cousin of petitioner number 1. A portion of the land was gifted to petitioner number 2 by petitioner
by the
number 1.
same person.
Same person, Lordship.
Same person has gifted to this. Okay.
Lordship. Lordship, if I may proceed.
Okay. So that way. The stretch of land of the petitioner in WPC 58 and 59, they are connected with.
Connected with. Portion of the land was gifted to petitioner number 2 through a gift deed, Lordship.
Okay. The original owner had gifted one portion of the land to
The petitioner
in the item 1 and portion to the petitioner in item 2.
Yes, in item 2, Lordship.
Okay. So it's a similar case.
Lordship.
Okay.
Lordship, if I may. Lordship, the brief fake of the case is that the petitioner in WPC 58, in item 1, he bought a piece of land at New Minister's Hill, Colony Kohima, and constructed a permanent structure and have been living peacefully with their family since 2010, Lordship. If Lordship can kindly come to page number 21, Annexure A of writ petition 58, Lordship. Lordship, this is the page 21, Annexure A, Lordship. Lordship, this is the residential certificate issued by the chairman of New Minister's Hill, Colony Kohima, declaring that the petitioner has been living in the said plot of land for the past 13 years, Lordship. Lordship, while purchasing this plot of land, the petitioner and the landowner executed a sale deed. Lordship, may I kindly turn to the next page, that is page 22, Lordship. This was executed between the landowner and the petitioner, as mentioned. And if your Lordship may come down to the bottom, it was duly authenticated by the Revenue Cum Settlement Officer, Office of the Deputy Commissioner, Kohima, Nagaland.
Okay. What was the age of the petitioner at the time of execution of this affidavit or sale deed?
Lordship,
12 years. This was on, no, 10 years.
Lordship. But Lordship, if I may, Lordship, thereafter, Lordship, the petitioner applied for land pata to avail loans, Lordship, and the land pata is at Annexure C, Lordship, the land pata.
This was in which year?
This was in the year 2014, Lordship.
And then he was at 2014, he was 14 years. Okay.
Lordship, this land pata was issued in the year 2014, and the petitioner has paid its premium till date, Lordship.
Okay.
Lordship, thereafter, a gift deed. A portion of the land was gifted to his cousin. Lordship may...
This petitioner gifted to cousin.
Yes, Lordship.
What is the name of the cousin?
The cousin is the petitioner in WBC 59, Lordship.
Okay. So this was gifted in which year? 2016.
Lordship may come to...
What was his age at that time? 16 years.
Lordship, I am not able to ascertain at the moment. 18 years, Lordship. 18 years, the gift deed.
This was
It's mentioned in the gift deed,
2016.
Lordship.
16, he was not 18 years. Okay, then?
Lordship, thereafter, as mentioned, a gift deed was executed and a portion of the land was gifted to his cousin.
Okay, just a minute. The petitioner in 59 claims the land on the basis of this gift deed.
Gift deed, Lordship.
Okay,
Gift deed.
yes.
And thereafter, Lordship, the petitioners applied for mutation, which is at page 28, Lordship. 28 and 29, Your Lordship. Your Lordship may... in page 29, you will see, Your Lordship will see the schedule of land, the boundary at page 29, Lordship. In the north, Minister's Bungalow. In the east, Pishokum, Yemchungar, he is the petition number 2. In the south, road. In the west, that is the vacant plot, Lordship.
Road, South Road.
Morning of 29/11/2023 at around 9 a.m., the petitioner was shocked to see the revenue officer, 5 to 6 dobashis, along with some police personnel outside his residence, directing him to immediately vacate the house. The petitioner replied saying he gave his reply to the restraining order, however, did not receive any reply from the Deputy Commissioner's office, which is the respondent number 3. The officials stated that they have already received the eviction order and they are there to evict the house. After due intervention, the revenue officer, who is the respondent number 4 in this instant case, replied that the petitioner should go and collect the eviction order from the Deputy Commissioner's office, after which the petitioner immediately left for the respondent number 3's office. On reaching the office and on perusal of the eviction notice, which is in page number 35, Lordship, second para, Lordship, it was stated, I may be allowed to read, Lordship. Second para, And whereas you have not complied with the notice order to vacate, evict from the said bungalow within the stipulated time, therefore it is necessary to evict such unauthorized illegal occupants by the government. Second para, Lordship. This is the eviction order passed by the respondent number 3, authority, stating that we are illegal occupants, Lordship. Lordship may kindly turn to page 36, the next page, Lordship. I may be allowed to read the first para. This is the grounds, Lordship. The first para, Lordship.
This is what notice this is?
This is the
This is ground.
grounds of the eviction order, Lordship.
Okay.
Whereas I, the undersigned, am of the opinion on the grounds specified below that you are illegally encroaching and undertaking construction activities within the Honorable Judge's bungalow, number such and such at New Minister Seal, Kohima, and that you should be evicted from the said land quarter, that earlier you have been issued notice under section 5(1) of the Act, and reply to the notice furnished by you has been duly studied and considered. However, after thorough examination, the reply is found to be insufficient and devoid of merit. Lordship. Lordship, this was issued on 25 September 2023, 25/9/2023.
Yes.
And if your Lordship can kindly see the copy 2 in page 36, in the bottom, Lordship, the copy 2. In the bottom, the tick mark is in number 3, office copy. Lordship, we took a photostat copy of this eviction order. This eviction order was never received by the petitioner at any point of
It is
time.
addressed to you? Addressed to the petitioner only?
Yes, but we never received this eviction order, Lordship. We never received this eviction order. Even this is a copy, photostat copy, Lordship. Even point 3, it was ticked office copy. We never received this copy. So, being aggrieved of this illegal order, the petitioner filed one writ petition before this honorable court, challenging the restraining order and the eviction order issued by the respondent number 3 authority against the petitioner. Lordship may kindly turn to page 37, annexure I, Lordship, which is the judgment and order. Judgment and order dated 12/12/2023,
Yes.
passed by this honorable court. Lordship, the operative portion is at page 40.
Yes.
Page 40, para 8. If I may be allowed to read, Lordship, in view of the above, this court therefore disposes of the writ petitions by this common order, thereby granting the liberty to the petitioners to approach the Commissioner, State of Nagaland, in terms of Section 12 of the Act of 1971 within 15 days from today. Lordship. Lordship, in compliance of this Honorable Court's direction, as per the judgment and order 12/12/2023, the petitioners have filed an appeal. Section 12 is the appeal provision in the Act, Lordship. So, in compliance of this Honorable Court's order, the petitioner has filed an appeal mentioning all grounds before the Commissioner, who is the Commissioner is the appellate authority, Lordship. Before the Commissioner, State of Nagaland, who is the appellate authority under the Act, whom we have implemented as respondent number 2 in the instant writ petition. The appeal was filed on 20/12/2023 and was duly received by the respondent number 2 authority on the same day, which your Lordship will find at page 42, annexure J.
Yes.
Page 42, annexure J. This appeal was duly received on this day, Lordship. We filed on this day and it was duly received. After filing the appeal, if your Lordship could come to my additional affidavit, Lordship. My additional affidavit filed on 10/7/2024. Additional affidavit filed on 10/7/2024. Annexure L, Lordship. Lordship, I may be allowed to read. Your Lordship wanted. Page 4, Annexure L, Lordship. Whereas an appeal petition has been filed by Shri T. Akumba Yumchinger and Shri P. Shokum Yumchinger, aggrieved by the restraining order number such and such, dated 16/6/2023, and the eviction order number such and such, dated 17/11/2023, issued by the Deputy Commissioner Kohima. And whereas on perusal of the appeal petitions, it is observed that the appellants claimed to have valid land patas and also valid allotment order. And the same documents have been annexed in the appeal petition. And whereas it is further observed that necessary clarification requires to be sought from the office of the Deputy Commissioner Kohima for disposal of the appeal petitions. Therefore, the undersigned authority deems fit to stay the operation of the eviction order dated 17/11/2023, passed by the Deputy Commissioner Kohima, and directs all parties to maintain status quo till further orders. This was a status quo order passed by the respondent. Lordship filed appeal on 20/12/2023, as per this Honorable Court's order, within the stipulated 15 days time granted by this Honorable Court, and on 12/2/2024, this status quo order was passed by the Commissioner, who is the respondent number 2. Lordship, now, while the status quo order was passed by the Commissioner, when the status quo order was passed by the Commissioner, respondent number 2, Lordship, may you kindly come to my writ petition, page 52. Lordship, when the status quo order was passed by the Commissioner, page 52, Annexure K, Lordship.
Yes.
Lordship, when the status quo order was passed by the Commissioner, respondent number 2, the respondent number 3, who is the Deputy Commissioner, on 16/3/2024, issued a cancellation order. Lordship, I may be allowed to read.
Just a minute. Okay, yes.
Lordship, I may be allowed to read. Pursuant to Commissioner Nagaland, Kohima, approval number such and such, dated 1st March 2024, pata number such and such in respect of Mr. T. Akumba Yumchinger and P. Shokum Yumchinger, respectively, at New Minister's Hill, Kohima, is hereby cancelled with immediate effect. Lordship, as you can see, this was given without any explanation, as you can see. Lordship, there is no explanation, it was plainly cancelled. When, Lordship, the appeal was pending before the Commissioner's office, which is the appellate authority. And your Lordship may kindly appreciate the fact that the status quo order is still operational, Lordship. Status quo order of the respondent number 2.
Yes.
Lordship, during the pendency of this case, this Honorable Court has also passed a status quo order, not to disturb the peaceful possession of the petitioner's land via order dated 22/4/2024. This Honorable Court has passed a status quo order. In the meantime, via this Honorable Court's order dated 4/6/2024, this Honorable Court allowed for implementation of Respondent number 6, represented by the Registrar, Gauhati High Court, Kohima bench. Lordship, here, when the status quo order passed by this Honorable Court was in operation, the petitioner filed a contempt petition on 27/6/2024 against Respondent number 3, Lordship, for defiance of the status quo order.
Who is respondent number 3?
It's the Deputy Commissioner, Lordship.
Okay.
Deputy Commissioner. For defiance of the status quo order passed by this Honorable Court on 22/4/2024, Lordship, as the state respondents have started to illegally construct permanent structure in the form of retaining wall, Lordship. Lordship, on 8/7/2024, the Commissioner, who is the respondent number 2, summoned the appellants, who are the petitioner in this instant case, Lordship, for hearing on the appeal petition. We were summoned on 8/7/2024, Lordship. Lordship may kindly refer to additional affidavit filed on my affidavit, additional affidavit filed on 7/8/2024. Annexure M, Lordship, page 5, page 5.
Additional affidavit filed on?
Filed on 7/8/2024. Annexure M, page 5, Lordship, page 5. Lordship, this
Where is the court status quo order? Okay.
Lordship, the status quo order is in.
Okay.
Lordship, this was the summon issued by the respondent number 2 under Section 12 of the Nagaland Eviction of Persons in Authorized Occupation of Public Land Act 1971.
Who is respondent number 2?
Respondent number 2 is the commissioner, who is the appellate authority.
Okay, who passed the status quo order?
Yes, even the commissioner has passed the status quo order, and even this court on 22/4/2024 has passed a status quo order, Lordship. There are 2 status quo orders.
22?
22/4/2024 passed by this Honorable Court. And status quo order passed by the respondent number 2, the commissioner on 12/2/2024, Lordship. Lordship, in compliance, we appeared in person. In compliance of this summon in Annexure M, which I've annexed in Annexure M. In compliance, we appeared in person, as well as submitted the status of the case, which was filed before this Honorable Court, and Lordship, at page 10, Annexure D. Page 10, Annexure D. Additional affidavit filed on 7/8/2024.
No, court passed status quo order on 22/4.
22/4/2024, Lordship. However, it was vacated, but I will come to that, Lordship.
Okay.
It was vacated.
Okay. Yes, then this summon.
Yes,
Please.
in compliance, we appeared in person, as well as submitted the status of the case, which was filed before the Honorable Court, before this Honorable Court, and
This
Lordship.
summon was issued for what? The appearance.
Yes, for hearing on the appeal, Lordship.
Hearing on the appeal.
Yes, by the
This summon
appellate,
was issued by?
by the respondent number 2, who is
Okay,
the
Commissioner.
Yes, Commissioner. He's the appellate authority, Lordship.
Okay, after cancellation.
After cancellation, Lordship. But this, we have challenged the cancellation order in this instant writ petition, and it was still pending. Before the appeal was still pending, so
While the appeal was still pending, and then the lane patta was already cancelled by DC, so this summon was issued.
yes, because the pending, the appeal was still pending, Lordship.
Okay, then what happened?
Lordship, in page 10, Lordship, annexure D, page 10, annexure D, of the additional affidavit, the Commissioner has passed an order on 31/7/2024.
Annexure
Annexure D, Lordship, page 10, of my additional affidavit, Lordship.
filed on
7/8/2024, Lordship.
No, and just a minute. After this summon, what is this reply intimation? What is this reply intimation to?
We have replied to the
summon.
Yes, Lordship. In written also we have submitted, and we have appeared in person also.
Okay, just a minute. Have you prepared a list of that? No.
No, Lordship. If needed, I can supply,
Okay,
Lordship.
this is order 31.
31 July 2024, Lordship.
It's
Annexure D.
Q.
Annexure D, Lordship.
It's not D.
Lordship, it may be the order, the additional affidavit which you are holding might be from 59, read petition 59.
Is it? Okay.
Yes. We are in 58, Lordship. No, Lordship,
Just a minute.
anyhow, I think
Yes, this is 59.
same order, Lordship.
Same order.
Same order. If your Lordship can,
Just a minute, just a minute. huh? Okay, file on 7/8 in 58.
7/8/2024, Lordship.
Someone is applying. Okay. And the order 31 July 2024 is annexure O. In any case, it cannot be D.
Lordship, it's, my apologies, Lordship. Annexure O, Lordship. Page 10, Annexure O. The my additional affidavit, Lordship, the Commissioner has passed an order on 31/7/2024, basing on our submission as well as the written reply. Lordship may turn to page 11, the last para, Lordship. The last para. I may be allowed to read, Lordship. In view of the above submissions and observations, this appellate authority deems it fit to keep the instant matter in abeyance till disposal of the writ petition by the Honorable High Court, Kohima bench. So as per this order, it was kept in abeyance.
Okay.
Lordship, the respondent number 6, represented by the Registrar Gauhati High Court Kohima bench, Lordship, they filed for vacation.
Respondent number 6.
Respondent number 6. They filed for vacation, modification, cancellation of the status quo order passed by this Honorable Court on 22/4/2024. Unfortunately, on 4/2/2025, Lordship, the status quo order was vacated. It was vacated not on the merits of the case. However, this honorable court relied on a full bench judgment, Lordship, 2024 4 GLT. Okay. Order dated 4/2/2025. 25. February.
Okay, by which order it was vacated?
4/2/2025, Lordship.
4/2/2025.
Yes, Lordship.
Must be here in order.
It was an IA filed by the respondent number 6.
Order is in IA.
Yes, Lordship.
IA number? Not reflected in the.
IA number 101 of 2025, Lordship. 2024. My apologies.
Okay, dated? Which date?
It was vacated on 4/2/2025.
4/2.
4/2/2025, Lordship.
Okay.
Lordship, unfortunately, it was vacated, not on the merits, Lordship, of the case.
IA number?
IA number 101/2024 and IA 102/2024.
Okay. Yes.
Lordship, it was vacated not on the merits, Lordship. However, this honorable court relied on a full bench judgment. 2024 4 GLT FB 779.
Okay.
Stating the status quo order in respect of the disputed land stands vacated by the provision of Article 2263 of the Constitution of India. Lordship, after the vacation of the status quo order, the status quo order of this honorable court, it was the commissioner respondent number 2 has again summoned the petitioners.
Again, thereafter?
Thereafter, after it the status quo order of this honorable court was
Last
vacated.
commissioner passed order kept in abeyance
Yes, Lordship.
till disposal of the writ petition. Thereafter also the commissioner.
Thereafter, yes, Lordship.
Again?
Again.
Okay.
So, Lordship, on 3/6/2024, we have filed our additional affidavit again, Lordship. If your Lordship can.
3/6?
3/6/2025, Lordship.
Okay.
Lordship, on 3/6/2025, we have filed our additional affidavit. If your Lordship can kindly come to page 5, annexure P. Page 5, annexure P.
Okay.
This was the summon issued by the commissioner, respondent number 2. This summon, your Lordship, was issued informing all parties to attend the appeal hearing on 23/4/2025 at 1 p.m. at the Commissioner Conference Hall. So in compliance to this summon, Lordship, we appeared as well as a written reply was submitted, which was duly received by the respondent number 2's office on 22/4/2025. It was received on 22/4/2025. After thorough submissions, the respondent number 2 reached the appellate authority as per the Act, Lordship, passed an order, which is at page 11, annexure R, Lordship. Page 11. I may be allowed to read the last 2 paras, Lordship.
Yes.
The Deputy Commissioner Kohima and the Revenue cum Settlement Officer Kohima was represented by one of his staff, Shri K. Krisilie. However, the representative could not make any submission in the matter. In view of the submissions made by the learned counsel for the appellants, this appellate authority deems it fit to further keep the instant matter in abeyance till disposal of the writ petition by same order, Lodge. Same order. Lordship, the respondent number 1 to 5 are the state respondents, and respondent number 6 have filed their affidavit in opposition.
Yes.
And we have submitted our affidavit in reply to the affidavit in opposition filed by respondent 1 to 5, the state respondents, as it covers the reply of respondent number 6 also, Lordship. Lordship, the petitioners herein are bona fide law-abiding citizens of India. Contention of respondent number 6. Contention of respondent number 6, which states that because of high security area which needs protection, the respondent number 6 have submitted a complaint against the petitioners. First of all, the petitioners have high regard and respect for the institution of judiciary. Lordship, if you can kindly turn to page 17, annexure 1 of the affidavit in opposition of respondent number 6. Annexure 1 of the affidavit in opposition, respondent number 6.
One series. Respondent number 6.
Respondent number 6, Lord.
Okay.
Page 17, Lordship.
Yes, page?
Page 17, annexure 1, Lordship.
Yes.
Lordship, I may be allowed to read
Yes.
para 1 and 2. In pursuance of Chief Minister's Secretariat, letter number such and such, dated Kohima, the 20th of July, 2021, quarter number AH44 is temporarily allotted to the Registrar, Gauhati High Court, Kohima Bench, for accommodation of honorable judges. The quarter number AH44 is to be reverted to the Chief Minister's Secretariat, CMS, on completion of the construction of the designated bungalows of the honorable judges at New High Court Complex, Merema. Lordship, here, the quarter was temporarily allotted to respondent number 6. The quarter being temporarily allotted to respondent number 6 does not mean to evict the permanent residents around the area residing around the area for more than 15 years, Lordship, who have constructed permanent buildings with proper land patas and permits. The petitioners did not encroach or disturb the allotted areas of respondent number 6 in any manner. However, instead, it is the respondent authorities who have constructed permanent structures illegally, even during the time the status quo order was in operation, Lordship. Till date, the illegal permanent construction that was made by the respondent authority is still standing, Lordship. This shows the high-handed manner taking the refuge of respondent number 6 authority. The petitioners are weak and mere public and are helpless, and till date, the petitioners are waiting for justice to be delivered, Lordship. The affidavit in opposition of respondent 1 to 5, Lordship. The affidavit in opposition of respondent 1 to 5, Lordship. In page 14, Lordship.
Yes.
Page 14, Lordship. Annexure 1 till page 21, Lordship. The respondent 1 to 5 has shown some unverified documents, which starts from annexure, from page 14, annexure 1 till page 21, which was neither issued by any recognized institution nor authenticated by the government. Lordship, annexure 1, page 14 till annexure 21. They are showing some list of the names of some individuals. However, it was neither issued by any recognized institution, as you can see, Lordship, nor authenticated by the government. We do not know under what circumstances the government authorities have annexed these unverified documents, Lordship. No letterhead, no signatures of any government officials, no nothing, Lordship. Page 14 to page 21, Lordship. As your Lordship also knows, the particular list pertains to government and not private individuals or private parties or individuals. And as such, whether these unverified documents can be taken as a piece of evidence before this honorable court. Again, as per the affidavit in opposition, Lordship, as per the affidavit in opposition of respondent number 1 to 5, they shifted from a legal perspective to a dramatic story of political intrigue and influence, Lordship, regarding the petitioner number 1's father, who was then a parliamentary secretary, which is irrelevant, Lordship. The government itself formally recognized his title through the issuance of land pata in the year 2014 and a mutated land pata in the year 2017. Now, if your Lordship could kindly come to WPC 59, Lordship. WPC 59. Here we have annexed the survey report, Lordship. Survey report dated WPC 59, Lordship. In page 30 and 31, page 30 and 31, annexure D2, Lordship. Typed copy is in page 31, Lordship. This is the survey report, Lordship. Survey report issued by the LRSO, Kohima, Nagaland, the Land Records and Survey Officer, Lordship. This was issued on 23/7/2017. Lordship, and the issuance of land pata dated 12/4/2017 to the petitioner against the plot of land, which is in the next page, annexure D3, page 32. Lordship can find the date in the top bottom, top corner, Lordship. 12/4/2017, Lordship. Lordship, in the affidavit in opposition of respondent 1 to 5, as well as respondent number 6, Lordship, they mentioned the word allotment order, Lordship. They are using the word allotment order. Your Lordship may please note that allotment order, if your Lordship can come to page, to WPC 59, 2024, page 32, annexure D3, page 32. The phrase the government respondents as well as respondent number 6 are referring this to allotment order on the top, Lordship. The phrase allotment order used by the respondents.
Top means?
Yes, the word allotment order, Lordship, of my land pata.
It's a land pata.
Yes, but the allotment order is there, Lordship.
Yes.
So, the phrase allotment order is used by the respondents is incorrect, Lordship, in their affidavits. The word allotment order refers to government approval for granting land pata to the landowner and not land allotted by the government, Lordship. Lordship, we have filed an RTI.
So, according to you, this allotment order,
Lordship.
This is a format only?
Lordship, in their affidavits, their contention is it is a land allotted to the petitioner by the government. But if it is not so, as per, I have filed an RTI.
It is not
Lordship.
allotment?
No, Lordship. Their contention is this land, their contention is this land was allotted to us by the government.
Yes.
But it was not so. We bought the land from a private individual, Lordship.
But then thereafter only allotment?
Lordship.
It was allotted?
Land pata was issued and an allotment order number was issued to us.
Okay,
Lordship.
it is allotment only?
Yes, Lordship. The word allotment order refers to government approval for granting land pata to the landowner.
So from private,
Lordship.
you said that it was purchased?
Yes, Lordship.
Okay, but then thereafter you obtained this allotment order? Private person cannot issue land pata. Whether the private persons from whom you purchased, the 58 and 59, from whom you stated to have purchased, whether that person have had any allotment order?
Lordship, it was bought from a private individual.
Okay,
After
what was his name?
Kivikile Soria.
Okay,
Lordship.
Kivikele had allotment order?
Lordship, your Lordship is well aware that the land holding system in Nagaland is a bit different, Lordship. The private individuals are landowners, Lordship, here. So, the contention which the respondent authorities are trying to put forward is the government has allotted a land to us. And not for, government has allotted the land to us. It was allotted by the government. They are of that contention. However, that contention is, Lordship, the word allotment order refers to government approval of granting land pata to the landowner, and not land allotted by the government. Lordship, we have filed an RTI before the respondent number 4 authority. We have not annexed it, Lordship. However, it is we have not annexed it because we wanted to know the stand of the government,
if
Lordship.
the land holding in the Nagaland is different, why you have obtained this land allotment?
Lordship, for the pata.
But this is land allotment only.
Lordship. Approval of granting land pata, we have applied for land pata.
This is a land pata, but then it is mentioned that allotment order number so and so. Government allot land from if the land belongs to government and a private asks for allotment, then only the government allot, isn't it?
Lordship.
So this is allotment.
Lordship, but
then
dear,
there's a procedure for
dear-
allotment also.
dear, their contention, the contention of the respondents is that
Okay,
the
let us
government
forget
has,
about the
Lordship,
respondent contention, your
Lordship,
contention.
Lordship, the government stand regarding banning of the allotment of government land, which they have annexed in page 36, Lordship. Page 36, annexure 13.
Of 59.
Lordship, the affidavit in opposition of the respondent 1 to 5. In
In 59. Or what?
Lordship 58, Lordship.
58.
Lordship. Yes, Lordship. Annexure 13. Affidavit in opposition of respondent 1 to 5.
Yes.
Lordship, the stand regarding
Page.
page 36, Lordship, annexure 13.
is a relevant portion.
Yes, Lordship. 36 to page 45, Lordship. Lordship,
36 to page 45. What is this?
36 to 47, Lordship.
36 is,
These are notifications on banning of allotment of government land.
okay, it should be from 37, I think.
36
36 is land patta. Continuation of the land patta.
in WPC 58, Lordship.
Okay, just a minute, huh? Okay, government land revenue department order.
Yes. On banning of
Just 36.
government land, Lordship.
Okay.
Banning of allotment of government land. Lordship, from page 36 to page 47. Till this, it is not applicable in our case, Lordship, because the petitioner did not receive any allotment of government land. As our plot of land is a private land, bought from a private individual, Lordship. So this, from page 36 to page 47, it does not apply in our case, Lordship.
Okay, so why you have obtained this allotment then?
Lordship, for a pata, we have applied, but the government did not give us the land. That is my contention. The government did not give us the land. We bought it from a private individual, but we needed a land pata to obtain loans and all. So we had to approach the concerned authority and we applied for land pata, and then allotment order was
Is
given.
land patta different from land allotment?
No, Lordship, but only because we had to obtain loans, we have applied for land pata, or else it is not a land which was given to us in the first place by the government.
And
It was bought from a private
is
individual,
there
Lordship.
any other option for like obtaining land possession certificate
Lordship,
if it is a private?
I'm not aware as of now. I'm not aware, but in the case of the petitioner, they have done so. It was bought from a private individual, but because of obtaining loans, they have applied for land pata, and the concerned authorities has also issued the land pata in favor of the petitioners. Not once, but twice, Lordship, in 2014 and in 2017, Lordship. That is my contention, Lordship.
What is the procedure for that then? Obtaining that kind of a land patta or allotment?
Lordship,
Is it the same procedure being followed?
Lordship.
Okay, then.
Lordship. Lordship, may you kindly turn to page 46, Lordship.
40
46.
of the affidavit in opposition.
Yes, Lordship, of respondent 1 to 5, Lordship. Lordship, this is a notification issued by the Deputy Commissioner. By the Deputy Commissioner informing all government departments which have not applied for land pata to apply for land pata issued on 25 to 2015, Lordship. Your Lordship, this piece of document in Annexure 19, page 46, this piece of document justifies their own illegal action which directly contradicts the order, as Your Lordship, in page 48, Annexure 21, which is the land pata issued by the respondent number 3, Lordship. This is the new land pata which was issued today in favor of it was, Lordship, it was issued to the EEPWD, the new land pata, with regard to the Judge's Bungalow, Lordship. It was issued on 9/2/2024, Lordship. This was the new land pata. So it contradicts, Lordship. This is a clear violation, Lordship. This is a clear violation of the order passed by the respondent number 2, via order dated 12/2/2024, whereby the Commissioner Nagaland has stayed the operation and directed the parties to maintain status quo. This land pata is in violation of the status quo order passed by the respondent number 2 authority, Lordship. The status quo order dated 12/2/2024, Lordship. Therefore, Lordship, the land pata, which they have manufactured is an afterthought. This was manufactured only after this writ petition was filed, claiming over the petitioner's land. However, the boundaries are not mentioned nor enclosed in the affidavit in opposition of respondent 1 to 5, Lordship. The land pata they have annexed as Annexure 21, Lordship.
Yes.
However, there is no boundaries, no north, south, east, west, no nothing, Lordship. The boundaries are not mentioned nor enclosed in their affidavit in opposition, Lordship.
It'll be in the second page, I think.
Lordship, but they have not annexed it. They have not put it on record before this honorable court, Lordship.
Okay.
And therefore, we do not know, Lordship.
It's on page 50, the boundary, the area, the
That is the map,
demarcation,
Lordship.
everything.
That is the map.
Page 50.
The boundary is on the left side, Lordship.
Lordship, but if your Lordship can come to the of page 50, on the bottom, Lordship, even the signature of the approving authority is missing, Lordship. It is left blank, Lordship. So, Lordship, we do not know if this document is authentic, manufactured, or whether it falls within the petitioner's land also, Lordship. The signature of the approving authority is also missing, Lordship. Page 50, Lordship. So, Lordship, now with regard to the impugned restraining order, Lordship, the restraining order dated 16/6/2023 and the eviction order dated 17/11/2023. On referring, your Lordship, they have, even the state respondents have even enclosed in their affidavit in opposition, which is at page 60, Annexure 29. Page 60, Annexure 29. And page 62, Annexure 31. The restraining order and the eviction order, Lordship. These two orders were, Lordship, issued, if your Lordship may, on perusal, Lordship, these two orders were issued in a most mechanical manner, Lordship. There is no reference whatsoever as to any specific plot of land, not to speak of indicating any specific land under the occupation of the petitioner. The said impugning orders do not even indicate the boundary of land in the restraining order as well as the eviction order. Lordship, the joint verification report is at page 57 of the affidavit in opposition, Lordship. Page 57, Annexure 26, page 58, Annexure 27, and page 59, Annexure 28, Lordship. Lordship, the so-called joint verification report dated 13/6/2023 in page 59, Lordship, Annexure 26. This was conducted, Lordship, if your Lordship has found it, page 59, Lordship. The so-called joint verification report dated 13/6/2023 was conducted in the absolute absence of the petitioner, Lordship, violating all principles of natural justice. On perusal of the said document, that is Annexure 26 and Annexure 27, page 57 and page 58, Lordship. A copy of these documents, Lordship.
Verification report, what do you say? What did you
Joint verification report.
Joint verification?
Yes, Lordship.
What is your objection here?
Lordship, here, a copy of these documents were never issued to the petitioner. This was one-sided, afterthought, and manufactured documents, Lordship. Your Lordship is well aware that any report generated from a one-sided exercise is inherently biased and inadmissible, Lordship. This was never, copy were never issued to the petitioner's Lordship.
Okay. Okay.
Lordship, the respondent's approval for cancellation of pata is at page 63, Lordship. Page 63 of the affidavit in opposition of respondent 1 to 5, Lordship. Lordship, here, the approval of cancellation of pata dated 1/3/2024. Dated 1/3/2024, issued by the Additional Deputy Commissioner, Office of the Commissioner, Nagaland, Kohima, followed by the impugned cancellation order dated 16/3/2025, Annexure 32, is illegal, without jurisdiction, and violative of Article 300A of the Constitution of India, without following due procedure of law, Lordship. The approval of cancellation of pata dated 1/3/2024 in page 63, Lordship, issued by the Additional Deputy Commissioner, was illegally issued when the order dated 12/2/2024, which is the status quo order issued by the respondent number 2, that is the Commissioner, Nagaland, Lordship, was still under operation, wherein the respondent number 2 state the operation of the eviction order dated 17/11/2023, passed by the Deputy Commissioner, and directed all parties to maintain status quo till further orders. Lordship, Lordship, the petitioner is a bona fide landowner, and right to property crystallized by the pata is an accrued right, Lordship. It cannot be extinguished by a mere executive order, and that too passed by an inferior officer without following due process of law.
Okay, what do you say about the eligibility of the petitioner, whether he was minor at the time of issuing land pata?
Lordship,
Can a minor be issued?
Lordship, the objection raised by the state regarding the minority.
Just my query. Answer my query.
Lordship, regarding the minority, the objection raised is frivolous, afterthought, being raised after 15 years, Lordship. In the meantime, survey was conducted not once but twice, Lordship, by the respondent authorities themselves, once in 2012, the other one in 2017, whereby in both cases, after following due procedures, they themselves has issued.
But you agree that at the time of this sale, execution of the sale deed, gift deed, and obtaining this patta also, he was minor?
Lordship,
Nothing to show that he was major. He was minor only. Okay.
no comment.
Anything else?
Yes, Lordship.
Okay. Yes, stay.
Lordship,
Anything else?
yes, Lordship.
In the year 2012,
Lordship,
in the year 2012, just a minute. Your father was the minister, isn't it?
Lordship,
And
yes,
occupied the quarter number AH44.
yes, Lordship. But it is irrelevant, Lordship. It is irrelevant, Lordship.
Okay.
It is irrelevant.
Just query. Okay. Anything
Lordship, the respondent number 1 to 5 in their affidavit in opposition have stated that the survey report dated 13/11/2024, the survey dated 13/11/2024 in Annexure 33, page 65 of the affidavit in opposition of respondent 1 to 5, supersedes our 2012 and 2017 survey report, which is motivated, issued under pressure to justify the illegal eviction and cannot override a right vested for over a decade, Lordship. The impugned cancellation of land pata order dated 16/3/2024 was passed while the petitioner's statutory appeal against the eviction order dated 17/11/2023 was still pending before the respondent number 2 authority, thereby making the action high-handed and predetermined. As such, the impugned restraining order dated 16/6/2023, eviction order dated 17/11/2023, and cancellation order dated 16/3/2024 is liable to be quashed and set aside. Lordship, the order of cancellation of the petitioner was issued. Here, Lordship, the order of cancellation of pata of the petitioner was issued on the same day the Model Code of Conduct for the 18th Lok Sabha election 2024 was implemented and became operational. That is on 16/3/2024, the same day. The respondent authority stated that it has no relevance, Lordship. Lordship, as you are aware, it is relevant as it prohibits the ruling party from using the state machinery for oppressive actions that can alter the voter's landscape, like evicting him from his residence. Lordship, the petitioners have their votes here in Kohima, and so the timing of the cancellation order which was issued is suspicious and reinforces the malified intent. Your Lordship, pertaining to the cancellation of pata, the state respondents, as well as the respondent number 6, have mentioned that where respondent number 1 to 5 have stated in their paragraph 12 of the affidavit in opposition, paragraph 12 of the affidavit in opposition, that the cancellation of pata is an action. Lordship, if Lordship may come to para 12 of their affidavit in opposition. Lordship, here in para 12, they have stated in para 12 of their affidavit in opposition that the cancellation of pata is an action taken from the revenue side under the Assam Land Revenue and Regulations Act 1886, and that the respondent number 6 have stated that the instant case relates to exercise of 2 different jurisdictions, Lordship. To this, I may be allowed to refer to Nagaland Code Volume 3, page 2, Nagaland Code. Page 2, Lordship. Lordship.
Page 2.
Page 2, Lordship.
Yes.
I may be allowed to read the meaning of public land, Lordship. Public land. It is in sub-para H, Lordship.
Yes.
Public land means any land belonging to or taken on lease by the state government, a local authority, a government company, or a corporation owned or controlled by the C-71 state government, and includes any land requisitioned by or on behalf of the state government. Lordship. Lordship, I bought this land, this plot of land, from a private individual, and so this particular meaning of public land does not attract to the petitioner. Lordship, I am aggrieved because I am not given an opportunity to be heard before the eviction order. And regarding the restraining order, the petitioner gave the reply. However, I was not summoned, nor any evidence was adduced, or there was no inquiry. They were silent, Lordship. Lordship, regarding the appeal section, section 12 of this act, section 12. Lordship, here I am to state that in this kind of appeal cases, particular procedures has been given, Lordship. Lordship, here I may be allowed to read section 12, subsection 1, subsection 1, Romans 1A of the Act, Lordship. Without prejudice to the provisions of subsection 1, the Commissioner of the State of Nagaland may, for reasons to be recorded by him in writing, transfer any appeal pending before him to the Additional Commissioner of the State of Nagaland, who shall dispose of the appeal as an appellate authority, appellate officer under this section, Lordship. Lordship, here, no doubt the Commissioner Nagaland, who is the respondent number 2, has acted on good faith by admitting the petitioner's appeal, Lordship, and has also issued a status quo order to all the parties. However, behind the Commissioner's back, the Additional Deputy Commissioner, under what authority he has approved the cancellation of pata, when the additional Deputy Commissioner is aware that an appeal is pending before the Commissioner's office. Is this justified, Your Lordship? When no such endorsement was also given to the additional Deputy Commissioner, which Section 12 of the Act dealing with appeal clearly specifies, Lordship. There was no endorsement as such. This whole procedure is illegal and regulated in a very high-handed manner, Lordship. Lordship, for cancellation of pata, if we go to the Assam Land Revenue and Regulation Act 1886, Lordship is much aware that there is no provision for cancellation of pata. To this, I may be allowed to refer to one judgment, Lordship, 2009 4 GLT 611, Lordship. Lordship, wherein it says, Lordship, Your Honor, I may be allowed to read from para 11, page 614, Lordship. Para 11. Starting from the 9th line of para 11.
This is regarding?
Lordship, this is regarding the cancellation of land pata as per the Assam Land Revenue and Regulations Act 1886, Lordship. Lordship, here, I may be allowed to read, Lordship, from the 9th para, Lordship. In the left bottom, Lordship, in the instant case, Lordship. Para 11, Lordship.
Okay.
Para 11, towards the bottom, the left bottom. In the instant case, Lordship, in the instant case, this court is of the view that the appellate authority cancelling the order of pata of the petitioner, which was the subject matter before the learned executive member, committed an error, and not only that, such cancellation of pata is also without jurisdiction. This court is in full agreement with the views expressed by the Honorable Chief Justice of the then Assam High Court that pata cannot be cancelled as there is no provision for cancellation of pata in the Assam Land and Revenue Regulation 1886, for short, Regulation 1886, which is applicable within the state of Meghalaya, including the Garo Hills Autonomous District Council. However, a pata can be annulled subject to non-payment of land revenue. Periodic pata means pata for a particular period, and if the pata holder paid the revenue, then he is entitled to get the title over the land mentioned in the pata as per law. But in the instant case, in the impugned order, there is nothing mentioned by the appellate authority that the present petitioner was a defaulter regarding payment of land revenue. Therefore, on that ground also, the order of the appellate authority cannot be sustained, as it appears from the record that the respondent number 3 made an allegation to the court below, inter alia, that the pata was obtained by the present petitioner secretly and in most illegal manner from the district council. The best course for the court below was to refer the matter to the civil court, as the revenue authorities has no power for such cancellation of pata under the regulation. Lordship, may come to para 12. For the foregoing reasons, the impugned order dated 9/7/2004, passed by the appellate authority, that is the learned Chief Executive Member District Council, is hereby quashed. In the result, the writ petition is allowed and the matter is remitted to the appellate authority to decide the appeal afresh only on the issue involved in the appeal preferred by the petitioner, after providing opportunities to the parties in the appeal. No order as to cause. Send down the LC. Record forthwith. Lordship, in my case, the petitioner's land is a private land, and for security and bank loans, the petitioners have applied for land pata. The land is not on lease, and no government authority does not have the power to cancel my pata. If at all the government respondents are aggrieved, Lordship is very much aware that this honorable court cannot decide on the issue of right, title, and interest, Lordship, my humble submission is that your Lordship is well aware regarding the land holding system in Nagaland. None belongs to the government unless taken, bought, or leased. The petitioner number 2, if your Lordship may kindly come to WPC 59/2024, Annexure D, Lordship. Lordship, in page 27, after the gift deed was gifted by the petitioner number 1 to petitioner number 2, the petitioner number 2 has applied for land pata, wherein he stated that in para number 2, I may be allowed to read, Lordship.
It's okay.
After this, Lordship,
He applied, and then he was granted, given.
this was a prayer for allotment of land permit.
Okay.
Minister's seal,
Yes, okay.
Lordship.
And accordingly, he was given.
Yes. The revenue officer, after this, Your Lordship, the revenue officer, in the next page, page 28, has requested the LSRO for survey of land on 16/3/2014.
Yes, absolutely.
Lordship, after a lapse of 3 years, on 23/3/2017, the LSRO has submitted its report to the Deputy Commissioner, Kohima, which is at page 31. And likewise, the pata was issued on 12/4/2017.
Yes.
This was in page 32, Annexure D3, Lordship. Lordship, basing on the pata, Lordship may kindly come to page 44, Annexure H. Page 44, Annexure H. Basing on this pata, Lordship, the RO has given its no objection certificate on 7/8/2017, where it says, I may be allowed to read, Lordship. This is to certify that Sri P. Shoko Myomchungar, son of R. Punkyu, has,
Yes, I've seen.
Lordship. On the same day, Lordship, the RO has given a land valuation certificate, page 46, Annexure H1. As per the prevailing market rates, it says the value of the land was valued at rupees 15 lakhs, Lordship. After that, Lordship, page 47, Annexure H2 is the non-encumbrances and mortgageable certificate issued by the RO on 7/8/2017. Lordship, if I may be allowed to read this particular para.
Yes, what you?
Page 47, the last para, Lordship.
Yes.
The plot is free from all encumbrances for the last 30 years. Also certify that the land under his possession is eligible for execution, lease, mortgage in favor of any nationalized bank or financial institution as per the provision of the Nagaland Land and Revenue Regulations Amendment Act of 2002. Lordship, at page 48 is the Annexure I is the construction permit issued on 23/7/2017 by the Kohima Municipal Council. And at page 50, Annexure J, the petitioner has been given the completion certificate issued by the Kohima Municipal Council on 5/2/2018. Lordship.
Completion of what?
Completion of residential building, Lordship.
There is a residential building there.
Yes, Lordship.
Concrete.
Concrete, Lordship. Lordship, why I am submitting this before your Lordship is because the petitioner applied for this pata to mortgage the land for housing loan in a bank, and till date he is clearing the loan, Lordship. As per the evidence
Pata
provided,
was issued on?
Lordship,
Pata in the present case was issued on which?
in 2017, Lordship, 2017, page 32.
Okay.
District.
April.
Next year, D3. April, Lordship.
Okay. Then construction permit,
Yes,
July.
Lordship. Yes, construction permit and completion certificate was also issued in favor of the petitioner, Lordship.
Completion certificate,
Lordship,
February.
Lordship, why I'm submitting this before your Lordship is because the petitioner applied for this pata to mortgage the land for housing loan in a bank until date he is clearing the loan. As per the evidence provided by the state respondents, they have given NOC stating that I have every right to demise, sell, lease out, mortgage, and it is free from all encumbrances for the last 30 years. So why now, Lordship? And this document was admitted by the government respondents, even in their affidavit in opposition, in para 8 and 9. The affidavit in opposition in WPC 59, Lordship. They have admitted. As such,
What they have admitted?
they have admitted as per the evidence provided by the state respondents, they have issued such and such. These documents were admitted by the government respondents, even in their affidavit in opposition. As such, Your Lordship, my humble prayer before Your Lordship is that the respondent 1 to 6 failed to make out a prima facie, has tried to justify with multiple afterthought documents, unverified evidence, high-handed manner with no jurisdiction, and as such I pray that they impugned the restraining order dated 16/6/2023, the eviction order dated 17/11/2023, and finally the cancellation order dated 16/3/2024 be quashed and set aside, being illegal. And I pray, and I further pray, Lordship, this Honorable Court, that the permanent wall structure that was illegally constructed during the pendency of this case be demolished. This is my humble submission. Much obliged, Your Honor.
Yes. Yes.
May I please, Your Lordship? Lordship, the petitioner, he could not establish his title and rights over the land over which he is claiming. He said that he purchased the land from one Sri KV Killian, Lordship, but he has never made the seller as a party respondent in the present writ petition. And Lordship, the government we have acquired the government of Nagaland, we have acquired the area of New Minister Hill and Aradura Hill from various landowners. So the landowners, these are the list of the landowners from whom we have acquired the land, and we have paid the compensation to the landowner. This is page 14. This is the landowners' name are mentioned here. None of the petitioners, none of the name mentions belongs to the seller's father or to his forefathers, Lordship. Page 14, page 15, 16, 17, 18, and 19A to 20, 21. These are all the records. This is a photocopy of the original receipt from the register, where we have paid the compensation to the landowners. And all along this area, this quarter AH 44 belongs to the government, and we have been allocating the quarter to different ministers. Lordship may start from this page 23, just to show how we have been allocating the quarters to different ministers. I have not annexed the full document, but just some examples only. Page 24, Lordship, this is order dated 13 March 2008. The following government quarters, yeah, page 24.
What is this, page 22? What is this?
Lordship, page 22, I will come back here.
Okay.
I'll come back to the sale date, Lordship, but here, first go to page 24. This is the order dated 13 March 2008. The following government quarters are hereby allotted to the minister, parliamentary secretaries, etc., shown against their name as below with immediate effect. If Lordship may come to serial number 24. This is Sri R. Tohomba, LOT, and the quarter number is AH44. Sri R. Tohomba is the father of petitioner T. Akamba in Writ Petition 58, Lordship. Then the next page, 25, this is order dated 6 March 2013. The following government quarters are hereby allotted to the minister, parliamentary secretaries, etc., shown against their name as below with immediate effect. If your Lordship come to serial number 22, the LOT name is R. Tohomba, the quarter number is AH44.
So this is 2008.
The earlier is 2008 and the second one is 2013.
Okay, same person.
Same person. So R. Tohomba, the petitioner father, has been occupying this quarter for a period of 10 years, Lordship. Yes. And it was during his occupancy, he wrote a letter to the DC, Lordship. That is at page 32. Page 32. This is Parliamentary Secretary CAWD, Nagaland, Kohima. This is the dated 28/2/2014. Please issue site permit in respect of Sri T. Akamba Yimchungar. This is T. Akamba Yimchungar is his son, measuring the land about 336 into 44 feet, acres, the said demarcation. He has mentioned this, Lordship.
This page 31.
Page 32.
Sorry, 32.
Yes, page 32. This is the letter to the DC by the petitioner's father when he was the parliamentary secretary of CAWD, Lordship.
Okay, this is petitioner.
Petitioner's father, R. Tohomba.
No. Who wrote his father?
His father wrote to the DC to issue permit
Son.
in respect of his son, Lordship. Yes. So, Your Lordship, all along this quarter and the boundary,
This is when this was written? This was
issued on
2014 when he was still under occupation?
yes.
Okay.
Yes. So, Lordship, all along this area we have acquired from different landowners, so it belongs to the government. And the quarter, from time to time, we have been allocating the land to different ministers and parliamentary secretaries, Lordship. And only in the year in 31, page 31, the quarter was temporarily allotted to the registrar, Lordship. Page 31. Yes. This is order dated 11 January 2022. In pursuant to the Chief Minister's Secretariat letter such and such dated 20 July 21, quarter number AH44 temporarily allotted to the Registrar Gauhati High Court Kohima Bench for accommodation of honorable judges. The quarter number AH44 is to be reverted to Chief Minister's Secretariat on completion of the construction of the designated bungalows of honorable judges at the new High Court Complex, Merima. So nowhere the land belongs to the petitioner. That's seller, Your Lordship, from whom the petitioner alleged that he purchased a portion of this land. Lordship, I may come to the writ petition also as to how the age of the petitioner. Lordship may come to writ petition 58, page 22.
Page?
22. Yes. 22, this is the sale deed executed by the petitioner and one Sri K.V. Kelia, Soria. So this is the sale deed dated 28/9/2010. In the sale deed, he has not mentioned his age, Lordship, petitioner age. But if your Lordship come to page 24, this is the gift deed where the petitioner said he gifted some portion of the land to his cousin. This deed of gift is executed on 17 August 2016 between T. Akamba Yunchinger, son of such an aged 18 years, Lordship. So if he, in 2016, if he is 18 years, then in 2010, he would be at the age of 12 or 13 years, acquired the land, Lordship. And erroneously, in page 23, this is the writ petition, page 23, the pata, 23 at 28, page 23 of the writ petition. Page 23 and page 28, this is the pata. These are erroneously issued to the petitioner, your Lordship, without the approval of the government.
Yes.
So, Lordship, here,
Page 23 and
28. These are erroneously issued. Yes, without the approval of the government. And Lordship may come to page 36 of my affidavit in opposition.
page
36. Lordship, here, since the year 1978, the government, we have been issuing orders and notification banning allotment of government land to private individuals or organizations without the approval from the government of Nagaland, Lordship. So page 36, 37, 38 to page 47, Lordship. Yes, and Lordship may come to page 44. This is notification dated 21 May 2005.
44.
Yes, page 44, where the government has said that the government department, they should apply for land pata. Yes, page 44, notification dated 21 May 2005. On the recommendation of the State Capital Complex Authority, the Governor of Nagaland is pleased to order and notify the following policies for proper management and maintenance of government land to holding by various government departments in the state capital, district headquarters, subdivisional headquarters, outposts, public institutions, and other government establishments extending all over the state of Nagaland for strict compliance henceforth. 1. Every government department shall have pata in respect of government land held or owned by them. 2. The pata should have been proper entry of area, boundary, and location supported by scale map in the Book of Land Records, Chitha Register. 3. The Deputy Commissioner, Additional Deputy Commissioner may issue pata to the Home Department in respect of Secretariat Administration, heads of department, heads of offices, and heads of institution by obtaining prior approval for regularization of land in favor of their respective departments from the government, and after ascertaining proper land records from the concerned land records of land with them, they must surrender such surplus land to the district administration by concerned authority in good faith. Further, no department has authority to issue no objection certificate for all allotment of land to others from the land under the possession pata land. 6. The Home Department, in respect of Secretariat Administration, various heads of department, heads of office, and heads of institution may apply the respective pata for the land holding by them to the concerned Deputy Commissioner, ADC, Deputy Commissioner in good faith. So, Your Lordship, this order notification is very clear that no objection certificate for allotment of land should be issued by the district administration. The petitioner is relying, showing some documents that the DC Commissioner Office has shown no objection certificate to that the land is free from encumbrance, Lordship. So, Lordship, basing on this notification, Lordship may come to page 48. This is the pata holder. Page 48, land pata book number 584. This is settlement order dated 9/2/2024. Name of department, Lordship: Executive Engineer PWD Housing and Estate Division AH 44.
Yes.
Yes, AH 44.
Yes.
Yes. So the area is 48,091 square feet, Lordship.
Yes.
Yes. Then Lordship may come to page 49. This is the
Earlier,
Yes.
you said that you acquired from the different individual persons by paying compensation.
Yes.
So area was mentioned.
Lordship, everything, Lordship, here, everything is mentioned.
This is pata.
Yes, Lordship.
And in the
Lordship, page 14, we have acquired the land from various landowners. This is a photocopy from the original register, Lordship. The area is above New Minister Hill, serial number, landowner, acreage, amount, received, date, Lordship. So there, yes,
area.
32 acres, 3 acres, 6.50 acres, the payment amount is mentioned, the date on which they received the compensation. So they received the compensation from the year 1972 to 1982, Lordship.
Is it regarding the entire area or?
Some pockets of the area, Lordship, some pockets, yes.
So how?
Above New Minister Hill, then Lordship, 15 Aradura upper. Then the rest are the areas and the receipt of the signature.
Okay.
So that area,
this quarter,
yes,
the bungalow
Yes.
was constructed only after acquiring.
yes, only
There-
after
thereafter
inquiries, yes. So it was an all government quarter. It is a government acquired land, Lordship, for which the government has built a quarter
Okay. Yes.
for the residence of the ministers and the parliamentary secretaries, Lordship.
Okay.
So earlier, prior to 2005, the government department, they do not have pata. So by notification 2005, the government notified that every government department should apply for land pata, Lordship. So based on which the EEPWD housing has applied, and page 94, this is the survey report, Lordship. Page 45. Yes, submission survey report dated 15 December 2023. Submission of survey report of land for office building and quarters under EE Estate Division, PWD Housing Kohima.
Page 45.
49.
49.
Yes. With reference to your letter number such and such and on the subject cited above, I have the honor to submit herewith the survey report for office building and quarter under EE Estate Division, PWD Housing Kohima. The survey as scheduled for 7 July has been successfully completed in the presence of JE, PWD Housing, DB, and duly surveyed, checked and verified by the technical staff of this office. The areas and boundaries are as indicated in the scale map and survey area list enclosed herewith for your ready reference, submitted for further necessary action. Then page 50, Your Lordship. This is the detail of land shown in respect of AH 44, Lordship. AH 44 for issue of land pata under estate division. So if boundaries, Lordship. The north is the private approach road, the east is private the south is road and the west a footpath private land. Whereas the petitioner, he is claiming the land within the compound, Lordship, within the compound of quarter AH 44. Yes. So based on this,
portion is the
Lordship, where the petitioner is claiming the portion, I'll show you. That is at page 56. Lordship, this is the picture, Lordship. He is even occupying the guard's quarter, Lordship. He has not constructed any house, only a makeshift, Lordship. And he is claiming this area within the compound of the judge's bungalow. This is within the compound, Lordship. Yes. These are the house, the two houses, these are the guard's quarter, Lordship. And he is claiming this area within the compound. Page 56.
in the map, it is in the map.
Yes.
If we come back, please come back to page 50. Private approach road. So approach road, private north, south. The petitioner is claiming in the east. Okay, the star mark, which
Yes, roadside.
is the claim portion,
Yes.
area not earmarked.
No, because it belongs to the government. It does not belong to the petitioner. It is a government land. That's why in the year 2023, when the survey was mapped, there is nothing show that within the compound there is a private
There is an
land.
existing building. Oh, is there any
No,
building?
no. There is no building. That is only the false allegations or false claim by the
no building
petitioner.
as such.
No, nothing. Because, Lordship, if we read the Law and Justice Advisor letter, Lordship, at page 55, he clearly mentioned on 17 August 2023. Yes. This is Advisor Law and Justice. In the month of April 2023, DC Kohima was asked to take cognizance of the serious encroachment of the compound of government bungalow AH44 converted into Judge Bungalow now. New Minster Hill, Kohima. It is presently under my temporary occupation. It is found that the entire upper side and some portion of the downside of the security fencing has been knocked down, and even the house guard quarter shown in the photo enclosed has been occupied by the encroacher openly. There is absolutely no security for the occupants of the building apart from losing the entire areas above the house. Before I vacate and leave for High Court judge to occupy, the security measure need to be taken on priority basis. Thus, the district magistrate has been asked to take immediate measure to prevent the encroachment by removing the encroacher, but so far nearly 5 months have gone, yet no sign of any action. In this context, even the High Court has sent an urgent complaint on the same issue for immediate action dated 24 April 23. It is most surprising, which has no logical reason to justify such an action for such a long time that calls for immediate corrective measure. I had expected DC Kohima for an expeditiously action to ensure that security could be maintained and at the same time land encroachment is prevented. Any further delay will have an adverse effect in taking preventive measure by the competent authority. So, Lordship, on receiving of the complaint from the Advisor Law and Justice, Land Revenue, then the Registrar Gauhati High Court, the DC, we have taken action. We have issued the restraining order, Lordship, to the petitioner. And even we have issued the eviction order and for cancellation of the pata also, Lordship. So, Lordship, it's very clear that he is claiming the land within the compound of the judge's bungalow. If at all he had purchased the land from the private person, Lordship, where is the necessity to apply for land pata? If it is a private land, land pata is not required. Only if it is a government land, only land pata is required, Lordship. But that shows as to how he tried to manipulate. He tries to manipulate the officers when his father is the men in power, Lordship.
Yes.
So, Lordship, based on which we have issued the verification report, issued the restraining order, the eviction order, as well as the cancellation. My learned friend has been pointing so much, saying that when the matter is pending before the commissioner,
Yes.
the
While
cancellation
the matter
was
pending.
yes, yes. But Lordship, the eviction order, that appeal is a different matter, and the cancellation is a different issue, Lordship. Yes. So, Lordship, he cannot claim on both the two, saying that when the eviction order appeal is pending, the commissioner ought not to have cancelled. Because the commissioner, he has cancelled the pata on the revenue side of the matter, Lordship. On the revenue side, Lordship.
Cancellation.
Yes, cancellation, Lordship. That's I have clearly mentioned in my para 12, that is at page 11 of my affidavit in opposition, Lordship. Para 12, Lordship.
Yes.
Yes. Para 12. That the statement made in paragraph 13, 14, 15, and 16 of the writ petition are totally misconceived by the petitioner, as the cancellation of the pata is an action taken on the revenue side under the Assam Land Revenue and Regulation Act 1886. Further, the model code of conduct for the 18 Lok Sabha election has no relevance when he is illegally occupying government land without government approval, Lordship. So when the petitioner is in illegal occupation, he has no right to challenge the action of the government in cancelling his pata. Now, Lordship may come to page 65, where the LRSO has given the rectification.
Yes.
Yes. Lordship, this is a letter dated 13 November 2024. The Deputy Commissioner, Kohima, Nagaland. Submission of rectification of survey report submitted by LRSO Kohima in respect of Judge Bungalow HH 44, New Minister Hill, Kohima. With reference to the letter received from the Office of Deputy Commissioner Kohima, White letter such and such dated 4/11/24, this office has carried out cross-examination of records and re-verification on the said land claimed by T. Akamba Yumchungar, son of R. Tohomba Yumchungar, at New Minister Hill, Kohima, and it has been duly verified and ascertained that the survey report submitted by the then LRSO Kohima, White such and such dated 20 of December 2012, because petitioner is claiming on this survey report, was erroneously issued, Lordship, was erroneously issued because the land in question falls within the government-acquired land. Therefore, it is hereby ratified that the survey report submitted by this office on 20 December 2012 and 23rd March 2017, survey report for bifurcation in respect of P. Shukum Yumchungar by T. Akamba Yumchungar hereby stands superseded by this report. So, Lordship, if you come to page 66, this is the survey report, Lordship. So, Your Lordship, if we compare with this page 66, the map, with the page 56 of the photo, it shows the electric post gate, yes.
Where is the photo?
Page 56. So, Lordship, it clearly shows that the petitioner is claiming the land within the compound of the judge's bungalow. So, Lordship, I may be allowed to read some of my affidavit. Lordship, may kindly come to page 7 of my affidavit in opposition.
Page
7.
yes.
Yes. Lordship, para 6, that the statement made in paragraph 2 of the writ petition is vehemently denied. The deponent states that the plot of land where the petitioner is claiming is government-acquired land. The government acquired the land of the area of New Minister Hill and Aradura Hill from various landowners, and compensation for the land was paid to the landowners between the year 1972 and 1982. Therefore, the land claimed by the petitioner is government-acquired land. Para 7. That with regard to the statement made in paragraph 3 of the writ petition is vehemently denied. The petitioner is the son of R. Tohumba, and it was during the occupancy of quarter number AH44 by Sri R. Tohumba, the petitioner, who was a minor around 12 or 13 years, entered into a sale agreement dated 28/9/2010 with Sri Kevi Kelia Sorhe, son of Kelia, for a plot of land measuring 336 into 44 feet 2010 within the compound of Minister Quarter AH44. The said land is government acquired land, and nowhere the name of Sri Kevi Kelia Sorhe or his father's name was shown in the list of compensated list. Therefore, Sri Kevi Kelia Sorhe does not have rights and titles over the land in question, as the said land is government acquired land. As such, the sale deed dated 28/9/2010 between the petitioner and Sri Kevi Kelia Sorhe is illegal and cannot be enforced. Even otherwise also, the petitioner is a minor, hence the sale is void ab initio, Lordship.
Now in the map, some private land.
The orders itself, Lordship, the allotment order itself shows that it is a government land.
Okay.
Yes, the allotment order itself shows.
Okay.
It is a government land.
Okay. Anything else?
And Lordship, he has not even made the petition, private the seller as a party in the present writ petition, Lordship. And Lordship, again, para 9 also, I may be allowed to mention, Lordship.
So typically, Sori is nowhere.
Sorhe is nowhere, yes. So that Sorhe, he has no rights and title. So whatever transaction between Sorhe and the petitioner is illegal, Your Lordship, and he cannot claim based on that illegal document. Seldi. Page 8, para 9, Lordship. That with regard to the statement made in paragraph 6, 7, 8, and 9 are admitted to the extent borne by the court. The deponent states that the land in question is not private land, but government-acquired land where compensation had already been paid to the rightful landowners. The pata was erroneously issued within the compound of government VIP quarter AH44 at New Minister Hill without the approval of the government. The Deputy Commissioner Authority, in receipt of letter number such and such, dated 24/4/2023, 9/8/23 and 28/8/23 from the Registrar Gauhati High Court Kohima Bench, to the effect that some individual have encroached upon Honorable Judge's Bungalow AH New Minister Hill Kohima, and certain portion of the boundary wall was dismantled and makeshift structure have been set up inside the compound. So, Lordship, whatever he says that he has built a house where completion certificate, all those are, Lordship, a way to manipulate, misconceive this court, Lordship. Only a makeshift structure have been set up inside the compound. The Deputy Commissioner Kohima was also in receipt of letter from the Advisor Law and Justice, Land Revenue, Nagaland, Kohima dated 7/8/23 to take cognizance of the serious encroachment of the compound of Government Bungalow AH44 converted into Judge Bungalow, where the entire upper side and some portion of the downside of the security fencing have been knocked down, where even the house guard quarter has been occupied the encroacher, and to take immediate measure to prevent the encroachment. Lordship, based on which we have issued the cancellation, the eviction, the restraining, and the order. And my learned friend, he has pointed out, relying on one judgment saying that the DC or the Commissioner Office, he cannot cancel, Your Lordship, which is not correct. Because as per the rules under the Land and Revenue Regulation, Your Lordship, under Rule 26, It is the confirmation and cancellation of settlement. Subject to the general control of the state government, the commissioner shall have power to confer all settlement and also to cancel any settlement, Your Lordship, made in contravention of this rule after giving the leaseholder an opportunity of being heard, Lordship. So the DC, the commissioner, he has authorized Rule 26, Your Lordship, of the of the Assam Land Revenue and Regulation Act 1886, Your Lordship. This is a part 2, chapter 1, settlement rules.
This was, okay, the Nagaland eviction of, sorry.
No, not the Nagaland, the Assam Land Revenue, Your Lordship.
Okay,
Otherwise, Your Lordship may see also.
okay.
Yes. My apology that I didn't bring the full set, Your Lordship. Just only Rule 26, Your Lordship.
26.
So when the pata is illegally issued, Your Lordship, without the approval of the government, we have cancelled. So it is within our power, Your Lordship. And when the petitioner has no right, he cannot say that the DC or whoever authority has no authority to cancel his pata. Under eviction, there is no
Give the copy of this.
Lordship, yes. And Your Lordship, this is my submission, and with regard to writ petition 59. 59, he derived his right from a gift deed by the petitioner in 58. So when the petitioner in 58 does not have a right, the petitioner no right, yes. So my prayer is that, Your Lordship, the writ petition is devoid of merit, Your Lordship, so it should be dismissed, Your Lordship.
Yes.
Yes, Your Lordship. Your Lordship, firstly, apart from, am I audible, Your Lordship?
He's muted. He is muted.
Muted. Yours probably is muted. You have to unmute it.
Yes, my Lord. It is unmuted, my Lord.
No,
Am I
it's
audible?
muted. It's muted.
Still muted.
Kindly unmute it. Yours. No sound. How?
He has to.
Unmute. You are need to unmute.
No, I think that's
Sorry, it's mute again.
Is it coming?
Is it coming, my Lord?
So from here, who is expert? Called. Can you separate it? This one. Can you separate it? Just would like to see.
Am I audible, my Lord?
Okay. So, the problem I'm told is from your side,
My lord, am I audible?
from
No.
your end. Is there anyone?
Yes, my lord. Just check again.
Can you talk to him if you can hear? Can you hear?
I can hear you, my lord. I can hear you.
Okay. But then we can't hear you. So maybe some defect in some problem
In my
in your
computer.
computer
Can we
that
try at 2 then, your
you're
lordship?
using. No, can't hear. It's not coming. You have to probably unmute it. Try.
Am I audible, my lord?
No, not coming. Not coming. Just, if Junior is there, ask her to call and then tell him that we can't hear. He has to.
Still inaudible. What's happening?
What he needs to do.
Can we try at 2?
Ask him what he need to do. What could be the problem?
Tell her, can we try at 2 to the problem? In the meantime, we'll get a correction.
So,
Tell her to tell the code.
at 2. Okay, we'll take up at 2 then. Your side only?
Yes, Your Lordship.
Okay, at 2. Okay. And then at 2, this matter. Yes.
For hearing item number 4 and 5.
So, petitioner,
Lordship, my senior, he's out of station and he's in bereavement.
who is it?
Yeah.
But what do we say? Can we proceed, or otherwise his part we have heard more than once?
Yes.
And if you think that we can go ahead with, or otherwise we can, since I'm coming in the month of December 2nd week also. So you think that his presence is necessary here in this case? Certain question, of course, certain query, not much. Hearing already done, but in certain query with regards to the land process in the present, the existing position.
Yes.
I need some actual answer.
Yes.
I have some query to him. So, but for that, otherwise it's already hard. To you also considerably, substantially, the hearing was completed. And of course, yours is in connection with the contempt only.
No, Lordship, read petition 58 also,
Oh,
Lordship.
58, sorry.
Lordship.
58
And another
is the
private
main.
respondent is there, who is the landowner, Lordship.
You are for, he's for,
I'm for the petition.
no, he's for a petition.
I am one of the petitioner, respondent, who is holding the license issued by the government.
Okay, so the
Yes.
subsequently
Lordship.
by the government.
Again,
How many, you are representing how many of them?
I am representing respondent number 6, the Monyu Union, Lordship, which comprises of about 20 villages under the Digit circle, Lordship.
So here, within the lane, the area,
Lordship.
permitted area, you have been allotted how much of
It's
the
just
land
a matter
from
of
the
80,
permitted
Lordship,
area?
80 by 80 around. It's just a small portion.
To how many people?
It's just allotted to a union, Lordship.
Oh, union?
Yes, Lordship,
So
which
union-
comprises of around 20 villages.
Within this area only?
Yes, Lordship.
20 villages?
Yes, Lordship.
In 150 acre, 20 villages, are they already?
80 by 80, not acre. It's an 80 by 80 square feet only, Lordship.
Okay.
So these unions form, these villages comprising of 20 villages.
Oh, 20 villagers?
Villagers.
Okay.
Form
So
this Land
Land is
union,
around, you said?
80 by 80,
80
square
by 80
feet.
feet, square
Yes,
feet.
Lordship.
And then some other person were also,
No.
they have not been made as a respondent.
No, Lordship, but the landowner has been implemented, Lordship.
But
The
landowner
sole
did not file
landowners.
any affidavit thereafter. He was
Lordship,
given
they have filed,
ample
Lordship.
opportunity.
They have filed, they have given
filed.
the appearance, they have given the argument.
Lordship, if you see, the Lordship, in the writ petition 58 of 2017, and Mozoy, who is representing the respondent number 7, they are the landowners. They are the landowners who have donated the land to the state government.
He is the original landowner.
He is the
Yes,
original
yes.
landowner. We are-
Okay.
None of the parties are disputing that.
Okay.
None of the parties are disputing that. The state government is admitting.
And one of the original landowner was also party in that complaint, probably.
No, Your Lordship.
ATC.
No. The landowners initially was not made a party.
Initially, he
Yes,
not-
but they filed a caveat before this honorable court. And then thereafter, IA impeding themselves. Because IA was allowed.
Now, it was pointed out last time that he was one of the person who, at that time, probably he also made a claim, I think. No? That's
That
it.
point,
Anyway,
yes,
but
yes,
then,
it is.
Yes. A certain Ang make a claim
Yes,
over
yes,
it.
yes, yes.
Yes. And then there
It
was
was
a memorandum
rejected,
issue.
rejected.
However, Your Lordship,
and then what is your submission regarding the High Court direction and the
correct.
Chief Secretary's
Correct. Correct.
direction that
Your Lordship-
administration should
Yes. Your Lordship.
honor the earlier decision.
Yes. Your Lordship, as far as if I may be allowed to make submission on this then, my Lord. As far as the Chief Secretary's letters is concerned, the only issue that is to be decided by this Honorable Court with regards to the Chief Secretary letter, can the Chief Secretary allot a portion of the land or allot any land to any individuals, those he have the authority?
He only observed that the administration in the district should
Yes.
honor the earlier decision of the
Yes.
administration.
And what was the
Okay,
decision?
Just 1 minute,
Yes.
one more. And then what about the High Court direction?
Yes. High Court direction was just to constitute a special inquiry committee.
Okay.
Special inquiry committee. So therefore, Your Lordship, as far as the writ petition, I have already mentioned that writ petition 2017 and 16 is not maintainable. I have made my categorical submission on that. So the only thing that is left is this WPC 88 of 2022. The WPC 88 of 2022, what is to be seen by this Honorable Court is whether the order passed by this Honorable Court earlier has been complied with or not. And has it been compliant in accordance with the direction passed by this Honorable Court or not. That is the thing that has to be seen, Your Lordship. And what was the order passed in the previous order was to constitute as committee as directed by the Chief Secretary. The committee, special inquiry committee was constituted, Your Lordship. And thereafter, report was submitted, Your Lordship.
Okay.
And
So
basing on the
according to
report,
that so this, according to you,
Yes.
this report is in accordance with the
Correct.
direction of the High Court.
correct. The issue, Your Lordship, the issue which has which the petition is pressing in 88 of 2022, but more particularly to land compensation that is supposed to be paid to him. The issue is not about who is the owner, Your Lordship, because that cannot be decided by this Honorable Court. And if at all the issue of ownership comes, Your Lordship, then the first thing a person who claims to be an owner.
When we say, when the Chief Secretary, the administration head of the state,
Yes,
says
yes.
that the earlier decision of the administration decisions
Yes,
is honored
yes,
by the present one,
yes,
what does it mean?
Yes.
What does it mean?
Administration order was giving him a special permit only. That's the only thing, Your Lordship. Therefore, Your Lordship, my submission will be this.
This observation was made when the petitioner made a complaint about the encroachment made by
Yes,
the private,
yes,
the government.
yes.
Then only this observation came from.
Yes,
the
yes.
Secretary.
Then Your Lordship, if that on the basis of that, if the petitioner is claiming ownership, Your Lordship, ownership will come only when he can prove that he has a title over that land. Without title, ownership cannot come.
And then see, But then the state also, without cancellation of this permit, special
Yes.
permit,
Yes.
whatever.
We have cancelled, Your Lordship. We have cancelled.
Before cancellation, the state has already allotted. Before cancellation,
Allotted to, Your Lordship?
allotted to the private and an
No,
and
no.
to the respondent number 6 also.
Your Lordship, not only the state respondent, the petitioner himself has sold
Yes, yeah, petitioner also, sir.
before the titleship of the land has been settled. The
Now-
petitioner
now-
also has sold.
Now, just okay. So leave apart the legality.
Yes.
So now, what is the stand of the, say for example, if it comes down, say for example, negotiate, if it comes, because the situation, one, you are raising the ownership.
Yes.
He doesn't have.
He doesn't have.
And one, your state head says, honor the earlier decision. Okay.
Yes.
And then you have cancelled, but then still he is holding.
No,
He
Your
has
Lord-
sold a
Correct.
large chunk of the land by
Yes.
the petitioner himself.
Yes.
And then state also allotted.
Yes.
So many people are there now.
Yes.
Probably 100 plus.
Yes.
Almost 200 people.
Yes.
Now, under the circumstances,
Yes.
this cannot be undo.
Yes.
Is
We
it-
cannot
is it-
undo, yes.
So under the circumstances, what according to you is the solution lies here?
See, Lordship.
Now, because today we are not taking up because the petitioner is
Yes.
not there.
We have.
In his absence, let us.
Yes, we have honored the letter of the chief secretary by allotting that portion of land which is in actual possession.
0.67.
Yes, we have already given him that is his actual possession, Your Lordship.
And then, and
The rest,
some sold or given or gifted away by the petitioner.
yes,
Some by the government.
Yes.
Like the respondent number 6.
yes,
And is there any other land, some land?
yes,
Remaining land?
yes,
With whom?
yes,
This
and
is
it was
under-
cancelled. Pata was issued and it was cancelled. After the inquiry report, there were other patas which has been subsequently cancelled by the government. Those pata was issued before the inquiry report came in, and we have cancelled it. We have cancelled those patas.
They are no longer there.
They are no longer there, Your Lordship. The report says it.
That means nobody is there then.
In a portion of land where the government have allotted land to private individuals, after the inquiry report, Your Lordship, some of the portion of the land we have already cancelled it because those allotment, those persons did not took possession of the land, Your Lordship, see. And because they did not took possession of the land, we have cancelled it, Your Lordship. As many as 12 patas.
Under whose possession at the moment the land is?
It is with the government now, Your Lordship. Those lands,
Except for this 0.67.
Your Lordship. Yes. And those lands which the petitioner have already sold, we are not asking it back because that will create a law and order situation, Your Lordship. So we are saying, okay, whatever has been done. We are not asking that back. And whatever, Your Lordship, here, one thing is to be noted, Your Lordship. The land that the government allotted is not only to private individuals, but for the establishment of the various government offices, Your Lordship.
What about that? Whether they have took possession of the land?
Yes, Your Lordship. There are so many other...
Department.
Yes, so many officers also are there, Your Lordship. And therefore, what we are saying is that the actual possession which the land which the petitioner is holding as of today is already allotted.
This allotment was before cancellation.
Before cancellation, Your Lordship.
Okay.
Yes. So the allotment has been done.
But you think that, do you really think that before cancellation of the permit,
Yes.
you can allot?
Your Lordship, see.
It was illegal.
Your Lordship, see. I'll tell you one thing, Your Lordship. How is the petitioner owner of this land?
How he is not the owner?
He is not owner of the land because he does not hold the title, Your Lordship. He does not hold the title. Your Lordship, see, in the state of Nagaland, the land holding systems are as such that I can get the title of the land through hereditary. One. Through purchase. Two. Or through, in certain conditions, allotment through the government. Is this a hereditary land? No. Is this a purchased land? No.
Special permit.
Is this,
for his contribution.
yes, is this the land, Your Lordship? Is this the land that the government gives title to the petitioner? No. If at all, the land is allotted to the petitioner. through an allotment order, and the Jambanbandi is being issued. Petitioner has got every right to say whatever he says, Your Lordship. I will concede. Without title, Your Lordship, over the land, how can the individual claim ownership over the land, Your Lordship?
How much land is this 0.067 acre would be?
Including his house, his fisheries, everything is there, Your Lordship.
No, so this is square meter, it will be?
Square, yes, it is, yes.
2,000 around?
Yes. Is his fisheries, his house, standing house, his compound, everything, Your Lordship.
Not big enough?
Big enough, Your Lordship. Even his fisheries. His fisheries also has been allotted to him.
From 154?
Now see, Your Lordship.
Only point?
Now see, Your Lordship.
Not even 1 acre?
Your Lordship, see, that allotment order that we have given it to him, if we encroach there, he has a right. He has a right. Because now he holds the title over that portion of land.
Now, even if this petitioner goes also, now the original landowner is now claiming, what would be your position?
Your Lordship, the original landowner's claim starts because the petitioner started claiming over that land. And that is why in their representation to the government, they clearly says that if individuals is allotted this much portion of the land, then they want it back.
Now, so many individuals have been already allotted.
Yes, yes. And so many sold.
And then under the circumstances, then the claim of the original landowner stands. Because even if this petitioner goes also, the entire claim, and he has been given this only a portion of land which is under occupation, and also the private person to whom the government has already allotted, and also the private person whom the petitioner has already given, and then to whom who later on obtain an allotment from the government. So this becomes individuals only. Then if this still survives,
yes,
then the original landowner will have still...
Lordship, that issue will be decided by the civil court. Because that issue is a title issue. And there are content of judgment issued by the Honorable Apex Court, where it has been clearly stated that the High Court under Article 226 cannot decide the titleship. And that will be titleship, Your Lordship. We are not concerned about the ownership here, Your Lordship, titleship. They are claiming titleship.
Some difficulties. Anyway, so then let him be present. Okay, let your senior come. Okay.
Your Lordship, on the second week of December, I have some difficulties, Your Lordship.
Oh, because this court tomorrow is the last.
Yes.
Then when? Then we'll have to release it from the part heard. Otherwise, I've heard. I know.
Yes.
On the other side, we have the condemn also where the standing structure half done is already there, and for the past 2 years, it has been just lying like that.
I thought, yes, today we will dispose it of because they did not inform us that they are not coming. So we all thought...
What do we do? What do we do? The release from the part heard?
Lordship,
your wish.
That is something which probably the parties may not be able to. We leave it to this Honorable Court, my Lord.
For me to no problem, but then since I'm coming in second week of December also, if you're not coming, the partner cannot be kept for such a long period.
Yes. Your Lordship, on second week of December, I have some problems because of certain family weddings, Your Lordship.
8 to 12.
Yes, Your Lordship. And it is not here, Your Lordship. It is not at Kohima. So I'll be going up and down because the marriage is supposed to be held in Dimapur. So I may be a little difficult. I don't want to release a matter and then again re-adjourn it, Your Lordship.
Okay. But anyway, let us try to get it listed that, and if there is difficulties, we will again post it then.
Your Lordship, if that is the case, why not list it somewhere in the beginning of next year?
Beginning of next year,
Your
the
Lordship.
second year, second week. That is beginning of the next year only. First week or second week. That is the beginning of the next year.
Your Lordship, 8
no,
to 12.
Next year.
No, yes, next year.
Next year.
Yes.
Next year is unpredictable. Whether this court. Anyway, then we'll release the, from partner. Otherwise, I've gone through. I've seen the case. Okay. You are seeking adjournment.
Yes, Lordship.
Okay. You are Sengla. You are Miss?
Ayala Imchin.
Oh, huh? Aya?
Ayala Imchin.
Lani Council. This is hard in part. No, it's too long because it was part hard. We kept it since July. I thought this time it will be finished.
Yes.
I was ready to carry a CAB, but then unless I have to release now, cannot keep for long. After expiry of 30 days, automatically, of course, it is released only, treated as released only. Anyway, Council appearing on behalf, okay, some is that our senior, Mr. Tongpok Pongner, is on a bereavement and pray for adjournment of the matter for the start. Mr. Anagami advocate for the state responded, and this is in 58. You are not in 58.
I'm 58, Lordship. I'm respondent number 6 in WPC 58, Lordship.
Oh, 58, you respond number 6?
Lordship.
Okay. Okay. Miss,
Apila, Lordship.
Apila, Miss Apila, for the respondent number 6 are also present. In view of the above, the matter is released from part third. List and as prayed for by the parties, let the matter be listed after the ensuing vacation. Vacation or what?
Yes, winter vacation.
Ensuing winter vacation. Okay.
Lordship, on behalf of all the parties, extremely sorry that the matters after hearing such a long period could not be decided, Your Lordship. On behalf of the parties, express my sincere apology, my Lord.
Let us try that this matter is listed before this court only.
Lordship.
Because this, since July,
Yes.
it was part hard.
Yes.
We cannot keep for such
Yes.
a long period.
We both
Only
thought
for
that
I'm
today.
releasing it. Only for that I'm releasing it.
Yes.
We'll get it listed.
Lordship, extremely sorry about this, Your
Lordship, there is an interim.
The interim order passed earlier shall continue till the next date of listing. Okay.
Obliged, Lordship.
Apologies and deeply
No,
obliged, my Lord.
no, no, no.
Obliged.
Yes.
for hearing item number 1.
Lords, Lordship, in this petition, kindly come to the page 42.
What is that? Yes. Yes.
It is page 42, para 24, last para number 24, last para.
Page 41.
42, 42, 42.
24. In page 42.
Para 24.
Yes, may I read, Lordship? It may be noted that the petitioner is neither named in any of the cases being number 1, Itanagar PS case,
Just a minute. Just a minute.
number 72.
Just a minute. Whether have you received the trial court record? Not a PP.
No, Lordship. Reminder may be, Lordship, given direction may be given to the registry to send reminder, Lordship.
Okay.
Lordship, it's been a many days that TCR has not come.
Lani counsel for the petitioner. I've also heard Mr. D. Loy, Lani public prosecutor for the state, who submits. Just a minute. The trial court record is still awaited. Stop. Issue reminder. Let this matter be listed next week. Next week.
Lordship,
Lordship, be it 24, Lordship, since Lordship sitting on 24, Lordship.
Lordship.
Just a minute. 24. Why 24?
Lordship is sitting on 24, Lordship, in eternal bench, Lordship.
Next week also I'm sitting. 18, no?
Okay.
18, okay.
Lordship, kindly the interim may be.
Just a minute. 18 because it's Sunday, Saturday. Mr. Loy.
Yes, Lordship.
Fix it on 20. Thursday.
Yes, Lordship. Yes, any date, Lordship.
Lordship, interim may be granted, kindly.
What
interim. Free arrest, Lordship.
No.
Lordship, because my name is not there in the FIR.
Itself will dispose of entire matter because you said that there is nothing, and on charge sheet your name is not reflected. If there is nothing in the charge sheet, you are there is no reason for apprehension also for your arrest because your name is not required at all. Okay. Yes.
For admission, item number 1 and 2.
1 and 2.
May please, Your Lordship. Lordship, am I audible now?
Yes. Now.
Okay, thankfully. So, Your Lordship, in addition to Rule 26 of the rules under the Land Revenue and Regulation Act 1860, which the learned additional Advocate General relied upon, there is another judgment of this Honorable Court in the division bench, which more or less renders the judgment of relied upon by the other side, which more or less overrules that, Your Lordship. Judgment of the division bench, which is reported in which is reported in 2023 1 GLT 634.
Okay. Para?
From paragraphs 32 onwards, but the relevant paragraphs are paragraph 32, which deals with the notification. Now, Your Lordship, this is in the context of the state of Nagaland issuing a memorandum saying that the deputy commissioners in the districts cannot allot government land without the approval of the government. So that was challenged. In the single bench, it was allowed. In the division bench, this Honorable Court came to the conclusion that it is fully within the competence of the government to issue such a notification, and that notification was upheld. In the Nagaland, it is in the context of the Nagaland case, Your Lordship. And this is in the context of the documents with the notifications which the learned additional Advocate General was relying upon. That no government land can be allotted without the approval of the government. So just to make that point clear, Your Lordship.
32.
Yes, paragraph 32. Beginning from paragraph 32. Has Your Lordship got paragraph 32? Yes. May I read, my Lord?
Yes, please.
Now, coming to the next question, as whether the learned single judge was justified in setting aside and quashing the impugned notifications, office memorandums, it would be relevant to take note of the office memorandum dated 26/7/25, which was prevailing at the relevant point of time when the impugned orders dated 1/10/25, 2005 and 6/12/2005 were passed. The said office memorandum, for the sake of convenience, is reproduced herein below. 26/2005. May I read again, my Lord? In view of the scarcity of land, government was exercising restriction for allotment of land to private individuals and issued numerous instructions from time to time. On 26 October 1992, allotment of land to private individuals has been banned by the government. Again, in July 1998, government had directed district administration not to allot any land to private without obtaining explicit approval from the government. Now, therefore, in the principle of the delegation of power and authority, all powers relating to regulation and management of land under government has been vested with the state government only. The existing ban shall continue till further orders. Henceforth, no government land shall be allotted to anybody without the specific approval of the government throughout the state. All the existing powers vested with the Deputy Commissioner, Additional Deputy Commissioner, Sub-Divisional Officer, Revenue Officers, Extra Assistant Commissioner for temporary settlement or temporary permit has been seized to operate with immediate effect. Any officer who is found acting contrary to the above instruction is liable to punishment under the following manner. If any government official is suspected to be violating the government instruction in regard to allotment of land, a departmental inquiry shall be initiated against him, her, by the concerned disciplinary authority, and if found guilty, appropriate penalty as prescribed under the Nagaland Services Discipline and Appeal Rules 1967 shall be imposed on the officer. This has been concurred by the PNAR Department, OM Cell dated 8/11/2004. Therefore, it is impressed upon that the above instructions shall be strictly adhered to by all concerned henceforth. So this instruction is still holding the field. Now, a discussion on the various authorities under the land revenue regulations takes place, and then Lordship can come straight to paragraph 42. Paragraph 42 at page 652.
Yes.
The power of the Deputy Commissioner for granting allotment of land in terms with the rules, therefore, in our opinion, is subject to general or specific orders issued by the state government. These impugned notifications, office memorandums would come within the ambit of general or special orders issued by the state government, and this aspect of the matter was also not taken into consideration by the single judge in holding that the impugned notifications, office memorandums were ultra-virus regulations and rules framed therein under, for which you are of the view that the impugned judgment and order dated 19/11/2010 is liable to be interfered with in the manner as indicated herein below. So this is what was upheld, Your Lordship. The notifications, memorandums stipulating that no government land can be allotted without the approval of the government, which was set aside by the learned single judge, was upheld by the division bench. And the division bench came to the conclusion that under the rules, under the land revenue regulations, the government has full authority to issue such notifications and instructions. So this is precisely what has happened in our case, Your Lordship. This is precisely what has happened. First of all, Your Lordship, if I may take Your Lordship shortly, very just briefly, to the writ petition. To the writ petition. What is the basis of the petitioner's claim? And the point which the learned additional AG made, the petitioner in WPC 59 derives from the petitioner in WPC 58. So if the petitioner in WPC 58 has no right, title, and interest to the land in question, he has no right to transfer anything. So therefore, 59 is dependent upon 58. So I will press my arguments only in relation to 58, Your Lordship. Now 58, if Your Lordship can come to the petitioner in WPC 58.
Yes.
The petitioner begins his claim by relying on annexures B and C, purported sale deeds, paragraph page 22. Page 22 is a sale deed, which is executed, purportedly executed in the year 2010. Has the Lordship got that? Now, Your Lordship will note that this so-called sale deed is executed on stamp paper of rupees 20. Has Your Lordship noted that? And also, it is not a registered document. Witnessed by the revenue officer is a different matter, Your Lordship. It must be a registered document. So the point I'm trying to make is this, Your Lordship. A deed of sale, in terms of law, must be properly stamped and it must be a registered document. If it is not properly stamped and it is not a registered document, it is inadmissible as evidence. And for that, Your Lordship can refer gainfully to Section 35 of the Indian Stamp Act.
Yes.
And Section 49 of the Indian Registration Act. The Registration Act of 1908 and the Stamp Act, Section 35 of the Stamp Act and Section 49 of the Registration Act. So these two documents are not documents which can be treated as evidence in accordance with law. So what remains then? What remains then, Your Lordship? In the affidavit of the state respondents 1 to 5, the sale deed is dated 28/9/2010, signed 28/9/2010, Your Lordship. Kindly note the date, 28/9/2010.
Yes.
Having obtained this so-called sale deed, and which the learned Additional Advocate General has also clarified, this person has got no right, title, and interest to any properties in the new ministerial area. He is not one of those landowners from whom land was acquired. Apart from the fact that if land was acquired, the previous landowners have no more right, title, and interest to the land which has already been acquired. Has Your Lordship got that?
Yes.
Then what remains now is Annexure C at page 23 of the writ petition. And Your Lordship will read this in conjunction with the application written by the petitioner's father, who was then a parliamentary secretary in the year 2014. In the month of February 2014, he submitted an application saying that a site permit should be given to the petitioner. And this land pata is dated 36/2014. And as Your Lordship rightly pointed out, in the first entry before serial number 1, pata issued by government approval number. Now, very importantly, Your Lordship, at page 23, after the first four entries, pata book number, old pata number, new plot number, then the next entry, pata issued by government approval number, there is no government approval number. Has Your Lordship got that? There is no government approval number. And yet, the Deputy Commissioner Kohima issued an allotment order. So this is not an allotment on the basis of a sale, Your Lordship. As Your Lordship rightly pointed out, if it was a sale, there would not have been a government allotment order. It would have just been a transfer of property, a deed of sale. So this is actually an allotment order which was given to the petitioner by the Deputy Commissioner without the approval of the government. Without the approval of the government. This also in the year 2014, after the so-called purchase in the year 2010. Now, in my affidavit, Your Lordship, can now come to my affidavit, the affidavit of the respondent number 6. So the first point of note I would like to make here, Your Lordship, is as far as my affidavit is concerned, there is no reply to my counter. Because I have made specific statements in my reply. If I may take your lordship straight to page 2 of my affidavit in opposition. As your lordship come to page 2.
Yes.
So the first at paragraph 3A. So this is the allotment order which your lordship has already gone through. So I will not repeat it again. So this allotment order for the accommodation of the honorable judges, this is an order which is not under challenge. This is an allotment order dated 11/1/2022. So if the petitioner claims that this plot belongs to him, this order also has to be challenged. This order is not under challenge. Then, what I have stated in paragraph B, your lordship may kindly note, I have made some specific statements. May I read, my lord? At page 3, paragraph 3B.
Yes.
May I read, my lord?
Yes, please.
Government quarter number 44, situated at New Minister's Hill, Kohima, is a bungalow with an enclosed compound. At the time of taking over possession of the said quarter, the registry of the Gauhati High Court Kohima bench noticed that a portion of the boundary wall on one side had broken/fallen down. Accordingly, action was initiated to repair the damaged boundary wall. Not long thereafter, it was noticed that a temporary CGI sheet wall had been erected and a portion of the land on the side where the boundary wall had been broken, fallen down, fenced off. As such, by letter dated 24/4/2023, the Registrar Gauhati High Court Kohima bench wrote to the Deputy Commissioner Kohima requesting appropriate action. So this is how the actions were actually started, your lordship. Now, all this resulted in a decision, a challenge by the petitioner in this Honorable High Court by filing the first writ petition. And your lordship has already seen that. This Honorable Court directed the petitioner to approach the Commissioner by way of filing an appeal. The point of note is the appeal has been filed, the appeal is still pending. The appeal is still pending. Now, much has been made, your lordship, much has been made about the interim order, the order of status quo issued on 12 February 2024 by the Commissioner of Nagaland. Does your lordship have that order? The order of status quo is Annexure L to the affidavit filed on 11/7/2024. Yeah, or 10/7/2024.
Okay, yes.
Yes, this is an order dated 12 February 2024. Now, what is this order of status quo, your lordship? The order of status quo is in relation to the eviction notice, the eviction order. Nothing more, nothing less. So till date, the eviction order has not been given effect to. The petitioner is still in occupation of the portion which is still in his occupation. He has not been evicted. So an order passed under the Eviction Act cannot be translated to mean that action cannot be taken on the revenue side. There was no stay on the revenue side. An inquiry into how the land was allotted to the petitioner was still an ongoing process. Now, this resulted, your lordship, again in my affidavit, of course, it is impugned in the writ petition, but in my affidavit, your lordship will see at page 25, Annexure 9.
Yes.
This is dated 1st March 2024. This is addressed from the Commissioner to the Deputy Commissioner of Kohima, Nagaland. And to all effects and purposes, this is the government addressing the Deputy Commissioner. Approval for cancellation of land Pata number 9791 and 9792 in respect of T. Akumba Yamchungar and P. Shokum Yamchungar at New Minister's Hill, Kohima regarding, with reference to your office letter dated 21st February 2024, and on the subject cited above, I am directed to convey the approval of the authority. So this is, the ADC is just conveying the approval of the authority. It is not the approval of the ADC. That is again a misconception, Your Lordship. So the ADC conveys the approval of the authority, which is the state government, for cancellation of Pata number 9791 and 9792 in respect of so-and-so, which were erroneously issued within the premises of government quarter number AH44 at New Minister's Hill, Kohima. So this was the reason for cancellation, erroneously issued. Firstly, Your Lordship, there was no approval in the government by the government prior to its allotment. Secondly, the Deputy Commissioner erroneously issued it within the quarters of AH44. Now, this approval order has also not been challenged. This is the basis of the cancellation, Your Lordship. This is the basis of the cancellation order dated 16/3/2024, which is in the next page. Has the Lordship got that? And the next page, 16 March 2024. Pursuant to Commissioner Nagaland approval dated 1st March 2024, that is the previous letter, in respect of so-and-so, is hereby cancelled with immediate effect. So the petitioner has only chosen to challenge this, but the actual basis of the order has not been challenged. Now, lastly, Your Lordship, in my page 32, this is again the order of the Commissioner in the appeal, which has been reiterated again in a subsequent order which has already been placed before Your Lordship by the petitioner. At page 33, with the above submissions and observations, this appellate authority deems fit to keep the instant matter in abeyance till disposal of the writ petition by the Honorable High Court, Kohima bench. So therefore, my Lord, firstly, the basis of the claim, the sale deed. It is a document which is no evidence in the eye of law to establish the petitioner's right, title, and interest to the land supposedly purchased by him. Secondly, the allotment order, Your Lordship will see, was not on the basis of any approval granted by the government. Thirdly, Your Lordship, the cancellation is one action. The action under the Eviction Act is another action. Two different actions altogether, and they do not correlate. Therefore, to say that the status quo order which was passed in the Eviction Act applies to on the revenue side or not, on the revenue side also, that is a misconception in law. Fourthly, Your Lordship, the cancellation order is based on the approval granted by the government. And according to the law laid down by this Honorable Court, the law has been, this Honorable Court and the division bench has upheld that unless the approval of the government is secured, the Deputy Commissioner cannot make any allotment. So the order which was issued is also in tune with the judgment of this Honorable Court and the division bench. Fourthly, and lastly, my Lord, there is an appeal which is still pending before the Commissioner's office. So there is an alternative remedy as far as the process of eviction is concerned. And that, if I may say so, Your Lordship, with all due respect to the appellate authority, the appellate authority ought to have exercised an independent, ought to have exercised its jurisdiction independently without waiting for the outcome of this writ petition. So in taking all these facts together into consideration, Your Lordship, my humble submission is that writ petition is devoid of merit and liable to be dismissed. So those are my grounds, madam.
Mr. Naktung Taylor. Sorry, Naktung Taylor. Anything, huh?
I can make a small submission.
Okay.
Lordship, the learned senior has stated that the the approval for cancellation of land pata order dated 1st March 2024 has to be challenged, Lordship, as stated. But this approval for cancellation of pata we never received until the filing of this affidavit in opposition. We were never aware of this approval for cancellation of land pata. So we cannot challenge, Lordship. And with regard to the settlement rules, Rule 26, Lordship, if I may read, Lordship. Confirmation and cancellation of settlements. 26, subject to the general control of the state government. The commissioner shall have the power to confirm all settlements and also to cancel any settlement made in contravention of these rules, after giving the leaseholder an opportunity of being heard. Lordship, we were never given an opportunity of being heard. And our pata has been cancelled. So, for this reason, we are before this honorable court praying that the cancellation order, the restraining eviction orders are illegal and are liable to be quashed and set aside, Lordship. That is my humble submission.
Okay. Mr. Nothing till that. Counsel for the petitioner. I've also heard Ms. P. Supri, Learned Additional AG for the state respondent number 1 to 5, and Mr. A. Zimomi, Learned Standing Counsel for the Gauhati High Court Committee, Kohima bench, respondent number 6. Hearing concluded, judgment, reserved, order reserved. Okay.
Supplies, my lord. No, wait.
Step 2, and then please print copy, please. Okay. Step 2,